mention.
Yes.
May I please, my lord. Item number 21, my lord. We kindly be adjourned, my lord. Only paper book I received 2 days back only.
21, okay.
21. It's a hearing, my lord. After vacation.
Adjournment.
Adjournment.
Hearing after vacation.
After vacation, it's fixed for
Alright.
hearing.
Maybe so, my lord.
Respondent.
I am for the appellant, my lord.
Appellant.
My lord.
General counsel for the appellant has paid for adjournment. This is the matter after vacation.
After vacation. Much.
May I, my lord?
You have
I will-
taken permission from the other side
One of the-
with the consent of the other side.
Yes, they stayed only.
Oh, state. Okay, state.
Yeah.
Always. Permission is not required.
May I, my lord? I would like to mention item number 14. This is a order. And as per the record, this is the steps taken showing regarding the earlier register post along with the as usual process. So may fix this matter after puja vacation so that I take the fresh step, my lord.
You want to take first steps.
Fresh step, my lord, because earlier 2 steps are still pending. So may allow for the fresh step, my lord.
You have seen the last office note.
Yes, there is no any update, my lord. That's
No
why.
update in the office note. No, I
That
know.
means from the side of the post office,
Ah.
there is no any update, my lord.
No update.
Whether the response is received or not. That's why I take the fresh step for the betterment of the case. And respondent is very clever to change his own address, my lord. That's why I send his fresh to some other address for betterment of the case.
Service report of unsubmitted notice received in respect of sole respondent
Yes, sole respondent husband.
by email on 25/9 through
Yes.
JMFC civil judge.
Yes.
JMFC comes civil judge is placed and marked a flag A. So maybe we have received back the, where is flag A? Okay. Market flag A. Not served. Notice person is not available. So how do you want to take first steps?
There is another address also there, my lord. Another substitute address also available. So on that part, I send a fresh step,
New address.
new address.
You will take fresh steps now.
Yes, my lord. Yes, another step.
You are
So
for the appellant.
appellant only. So
The counsel for the appellant, Mr. Franco, has prayed or has submitted a fresh steps will be taken to the appellant to the respondent number 2. Sole respondent's
Sorry.
new address.
address.
Is the matter on? When do you want?
After 4 weeks, my lord. So
After 4 weeks.
after 4 weeks. Much obliged.
May I pleasure also, I would like to mention bail application
Hmm.
already filed.
Hmm.
And this matter may be taken up with along with item 11.
Item 11.
Yes, it is same CD.
Now,
Yes,
mention now.
item 11.
Will you be able to get it?
Already filed.
Okay, we'll try.
Okay.
We'll take up as the last matter.
Okay.
My lordship.
Hmm.
Lordship, I beg to mention item number 13, lordship. Leading counsel is out of station, lordship. Matter may be listed after puja.
My lord, I am for the respondent number 2 in this case. My lord, in my affidavit in opposition, there is one typographical error. Name of petitioner is wrongly as Jardim Longri and Jardim Longri instead of Junjar Longri. May I allow the correction?
There's one notification, I don't know, I think you'll have to file amended. New notification circulated. I think you have to file amended cost title, I think.
not in post title, in my annexure. It is one type copy is there. It is wrongly typed as instead of junior law, it is Arjun law.
Through petition maybe. You can apply through petition. I don't know. There's a notification circulated. I forgot the notification, whatever the contents of the notification I have forgotten. I think you have to file a petition, huh? I think
In
so.
annexure only.
Yes, yes.
I have to amend the petition.
Amended petition. No, she is talking about an annexure.
In
Annexure
in
also.
annexure, in type.
What
copy.
about annexure?
I
So you'll have to file a petition.
Yes.
After Puja break, Lordship.
Learned counsel for the petition is out of station.
Lordship.
List the matter after puja vacation.
All right.
My lord, I beg to mention item number 20, my lord.
20,
20. My lord, it may be listed after 6 weeks.
6 weeks.
Yes,
Learned counsel for the petitioner, Mr. Surenso, for the petitioner has
Yes.
prayed for adjournment. List the matter after 6 weeks.
yes, yes.
My lords, item number 12, I am for petitioner, may be allowed to be adjourned,
All right. All right.
listed after, maybe listed after puja.
After puja vacation. Item number 12.
12. Oblige.
Mayor Lordship. Lordship, I beg to mention item number 7. On behalf of Mr. N. Sharma. My lord, leading counsel is out of his station, man.
My lord, I appear for the private respondents, my lord. Mr. Sharma called me up in the morning. He said he's unwell.
Learned counsel, Mr. N. Your name?
Kya do?
Mr. K. Alam on behalf of Mr. N. Sharma, learned counsel from the for the petition with the consent of the other side. With the you want your name to be
My
mentioned?
lord, my lord.
With the consent of the learned counsel for the respondent, Mr. P. D. Nair has paid for adjournment. List the matter.
On 17 November.
Miss L. Hage. Learned addition PP for respondent number 1.
Yes, ma'am.
My lordship, I beg to mention items 17, 18, and 19. It is analogous case for the respondent. I'm on behalf of K. Lolen. The
You've
learned-
taken consent from the other side.
Yes, lordship. That is it.
Petitioner. Learned counsel for the respondent with the consent of the other side has paid for adjournment. List the matter after vacation.
Yes.
After vacation. 17, 18, and 19, okay?
Much obliged.
My please, Lord. My lord, in this matter,
Yes, sir.
the respondent, my lord, in item number 1, the respondent has filed a title suit before the learned civil judge senior division in Sepa East Kamen district regarding the plot of land which is located as Seyusa now Paki Kesing district. Lordship, after notice was issued, your lordship will kindly come to page annexure 1. I'm sorry. Here, my lord, on page 10, my lord. Yes.
Yes.
Both the learned counsel are present, defendant Sri Techi Hemu is present. Today, case was fixed for filing retained statement for defendant number 7. Retained statement is not yet filed by the defendant number 7. Next date is fixed on 38, 2023 for filing of statement of defendant number 7. Thereafter, my lord, on 38, lordship will find page 11, my lord. We are challenging this order. Learned counsel such and such are present. Learned counselor such and such is present. Here, madam, down below. Today, the case was fixed for filing of written statement of defendant number 7. Madam, I am the defendant number 7. Madam, the present petitioner. Learned counsel such and such has submitted that he is ready with a written statement and same was presented befor the Shrestha. However, the same was written on the ground that some of the annexes are not legible. Therefore, he prayed this court to allow him to file written statement on next day. On the other hand, learned counsel Mr. Such and such submitted that defendant number 7 have not filed his written statement within the statutory period of 120 days. Therefore, he may be barred from filing written statement. Since the written statement is not yet filed within the statutory period of 120 days, this court is inclined to proceed the case without a written statement. Accordingly, case is proceeded for documental issues. This is the matter. So it is not, as a petitioner, it is not my fault. I filed a written statement on 38/2000. I have signed. Because of some documents during the Xerox, they were not legible. So matter was written on 30. And the matter, because of lower, there are not much cases, it reached. Then 2005 itself, that the mandatory period which is given under order 8 rule 1 of CPC, it says shall be filed within 90 days. But Honorable Supreme Court says that shall is not mandatory. It is only directory. And
Notice.
yes, my lord, why I'm saying this, my lord, the proceeding has to be stayed, my lord. Otherwise, if it is completed, they might pass judgment also, because I have not been allowed to file a written statement. My lord. Thereafter, nothing remains, my lord, because the court can pass judgment also under order 8 also. That's why the proceeding may be stayed, my lord. Scan the scan copies of the, if necessary. Otherwise, it's not necessary. Notice may be.
Relevant paragraph in your petition?
My lord.
Paragraphs in your petition, relevant paragraphs where you have given your prayer,
My lord,
not prayer portion, where you have given your reasons.
my lord, here only, my lord. The learned counsel, Mr. Sessions, has submitted. He is ready with the written statement, and same was
No, no.
presented.
Petition.
No petition was filed, my lord.
No.
Oh,
Petition now.
okay,
Regular
my lord.
petition.
Yes. We have, my lord, in the grounds we have given, my lord. Page 6.
I can pass a common order for all the 5 petitions.
Yes, almost only the names are different. Almost everything is ditto, my lord. If your lordship wants, we didn't want to travel. Otherwise, I have the citation of the Supreme Court, my lord. First is, my lord, 2005 6 SCC 344. Lordship will find this is para 20, man.
Yes.
Here, the use of word shall in order 8 rule 1 by itself is not conclusive to determine whether provision is mandatory or directory. We have to ascertain the object which is required to be served by this provision and its design and context in which it is enacted. Thus, the use of word shall is ordinarily indicative of mandatory nature of the provision, but having regard to the context in which it is used or having regard to intention of the legislation, the same can be construed as directory. It's not mandatory. In para 21 also, my lord, it's conclusive. In para 21, Your Lordship allows, I'll read.
Yes, yes.
In construing this provision, support can also be had from Order 8, Rule 10, which provides that that where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by the court shall pronounce judgment against him or make such other order in relation to the suit as it thinks fit. On failure to file written statement under this provision, the court has been given the discretion either to pronounce judgment against the defendant or make such other order in relation to the suit as it thinks fit. In the context of provision, despite use of word shall, the court has been given the discretion to pronounce or not to pronounce the judgment against the defendant, even if the written statement is not filed, and instead pass such order is as it may think fit in relation to the suit. In construing the provision of Order 8, Rule 1 and Rule 10, the doctrine of harmonious construction is required to be applied. The effect would be that that under Rule 10 or Order 8, the court in its discretion would have the power to allow the defendant to file written statement even after expiry of the period of 90 days provided in the Order 8, Rule 1. There is no restriction in Order 8, Rule 10 that expiry of 90 days further time cannot be granted. The court has the wide power to make such order in relation to suit as it thinks fit. Clearly, therefore, the provision of Order 8, Rule 1 providing for upper limit of 90 days to file written statement is this directory. Though it the shall is written, but it's a directory. Yes.
Sorry, in this order, only you are aggrieved, only 1%.
Yes.
Given in number 7. And the other cases?
Madam,
CRP 4,
yes, yes.
item number 2, 3, 4, and 5.
Yes, but in item number 2 also, my lord, the respondent.
You're aggrieved by the same order.
Yes, every same order. Same order, but case numbers are different. That's all. I have annexed the orders also, but the orders are same, ditto, my lord. The case number is different and party name is different. Where I'm respondent number 7 in all the cases.
You respond number 7 in all the cases.
Yes. Your Lordship will just next.
This case are analogous. All
Analogous
cases are
case.
analogous.
I have a LPC plot of land, my lord. These people, they are challenging my allotment. They're saying that it's theirs. If your Lordship sees the item number 2.
Item number 2.
There also, my lord,
Techie hemo.
yes,
3 also techie hemo.
yes,
4 also.
yes,
Yes. Okay.
yes, sir.
Okay. So the names are same, cases are different. So you can write the same thing for all the cases. Third, Mr. P. Taffo,
Yes, madam.
learned counsel for the petitioner. The petitioner has filed an application. Filed this revision petition. Filed an application under Article 227 of the Constitution of India, read with section 115 of the Code of Civil Procedure. Seeking quashing and setting aside of the impugned order dated same date,
Yes, ma'am.
dated 3/8/2023 in TS number so and so.
That will differ, madam.
That will be different.
And party name also will differ.
Thirty-eight 2000.
Yes.
The order dated 38/2003 passed by the learned Civil Judge Senior Division SEPA,
Yes. Is coming.
is coming, reflects that the written statement of the petitioner was not accepted. Not accepted.
Yes.
Written statement of the petitioner was not accepted in connection with TS number so and so as statutory period of 20 days had already elapsed.
Yes, ma'am. That's
The learned counsel for the petitioner has relied on the decision of Honorable the Supreme Court in Salem Advocate Bar Association versus Union of India within bracket 2005-6 bracket close 2005 bracket close 6 SCC 344 wherein it has been held and observed para 21 and 22 para 20 and 21
yes.
paras 20 and 21. I have considered the submission of the learned counsel for the petitioner. The petitioner sufficient grounds has been drawn up for stay of the implement order. Issue notice to the respondents, how come to registered post?
Registered post.
To registered post with AD, returnable within 4 weeks.
Yes, ma'am.
List the matter accordingly. Meanwhile, the implement order dated 38/2023 is stayed until till the returnable date.
Obligation.
Oh, you are for respondent?
Yes, sir.
You have accepted notice?
If performer responded, I have already served.
After the first line, insert this, heard Miss
4, 5, and 6.
for respond number 4, 5, and 6.
I am for 1, 2, and 3.
Respond number 1, 2, and 3. Issue notice to the remaining respondents.
Yes. Obligation.
Yes.
May I please? My lord, here, this is a criminal petition, my lord. The petition is agreed by the, my lord, the registration of the second FIR. And on the basis of second FIR, charge sheet has been filed. And my lord knows that law says, my lord, second FIR is not permissible. And therefore, my lord, all the consequential action based on second FIR is legally impermissible, my lord. I will show, my lord, how this second FIR relates to the same cause of action, my lord, the same incident, my lord. It happens something like, my lord. This is the petitioner.
Let us see the first FIR.
My lord, my lord. First FIR. Page 79, my lord. Let's start from say 79, my lord. 81 is the contents, my lord. My lord. May I read, my lord? My lord. With due respect and humble submission, I would like to state that I park my Bajaj Pulsar model number so and so bearing registration number so in the roadside at Tengu Niri near Harigate 4 so and so today on 22/3/2023 at about 2 AM. I park my motorcycle in front of an Alto car bearing registration number so and so. My lord, it is very important here. This motorcycle is in front of Alto car. My lord. Another motorcycle belong to so was also parked nearby my motorcycle. Suddenly, a Scorpio car bearing registration number driven by Sri K. Pertin coming from Zero side hit the Alto car, my lord. First, that Scorpio, my Scorpio hit the Alto car, my lord, and my motorcycle, causing huge damage to Alto car and my motorcycle and ran away without stopping. We shouted at the driver of the Scorpio car to stop, but he did not stop. Thereafter, Sri Talyang Richo followed the Scorpio car with his motorcycle, stopped the Scorpio car near Jimin Zero Hotel. I, along with Sri Tapi Tasang, followed the Scorpio with another car belonged to friend Tapi Tasang. We found Sri Talyang Richo and Sri Pertin near Hotel Jimmy. Has confessed before us he had my motorcycle and Alto car of Sri Tapi Tasang. He has committed offense of hit and run causing so and so. My lord.
Second FIR.
Second FIR, my lord, lodged by owner of the Alto car.
Which page?
My lord, I will show. Page 16. Well, page 17, my lord, will find. This is complaint is the owner of the Alto car, my lord. The earlier one is the motorcycle. I am writing, this was laws, my lord, subsequently on 18/4/2023. Earlier was laws on the day 22/3/2023, my lord. After almost 1 month, this FIR was lost, my lord. I am writing this letter to file a report for car accident that occurred on 22 March at 0 at around so and so Sri Ganam Patin, an employee of State Bank of India in an inebriated condition, hit my parked Alto car bearing registration number so and so. So, my lord, what he is referring, this is the same Alto car, my lord. My lord, what happened on that night? That first my Scorpio accidentally hit the Alto car, this car, and in front of that Alto car there was a motorcycle, Bajaj. And when I hit the Alto car, then because of that Alto car again hit the motorcycle. Then immediately on the next day, the owner of the motorcycle lost the FIR, saying that I hit the Alto car as well as his motorcycle. The case was registered, my lord. Then investigation is still undergoing. Now, my lord, here my lord has seen after more than 1 month, again the owner of the Alto car, he lodges the FIR. And on the basis of this FIR, my lord,
He had a prosecution. Yes.
my lord,
Yes, Your Lordship. Your Lordship will, as per the state submissions being made, Your Lordship, though the incident is of the same day, same time, Your Lordship, but the complainants are different, and each of the complainant has their own grievances with regard to. Your Lordship will see in the FIR, first FIR, the submission being made that the Alto was hit, and the Alto hit the bike is totally wrong, and it has been clearly reflected in the FIR that first it was the Alto that was hit, that was owner of the Alto was different, and then his bike was also hit.
We'll issue notice.
my lord will see.
Yeah.
So
Yeah.
far the fact
Will
is that
issue-
admitted,
Yes, Your Lord.
issue notice, but here is that the trial of the case on the basis of second charge sheet is fixed on 31st of October, my lord. That has to be assured. Definitely we will examine. Law says what, my lord? All the subsequent FIR or whatever that will come under the 161 statement, my lord. My lord, judgment, my lord, it's a settled law, my lord. I think TT Anthony case, my lord. There was recently Arnab Goswami case also, my lord. It's very plain, my lord, and reading of, my lord, chapter 12 of the CRPC and reading of what is FIR, my lord. The first information,
You have come up with the second FIR.
Yes.
I am for the second FIR on the basis of which, my lord,
Or
starts.
lost after 1 month.
Yes, my lord. My lord, my prayer is, my lord, at this stage, my lord, during the pendency, of course, we will examine, my lord, that part. And because, my lord, this case, charge sheet has been filed on the basis of second FIR. The investigation into the first FIR is still pending, my lord. Now, my lord, next date of the case is fixed on, my lord, is number 82. 31 of this, my lord, October, my lord, for offense explanation, GR case number 15. So that, because otherwise, my lord, if that case proceed, there is no basis of, my lord, challenging this criminal petition itself, my lord.
They can challenge
that-
at any point of time during, even after the CC is being claimed. There is no hard and fast rule with regard to 482, Your Lordship,
No.
anytime.
My lord, that's why, my lord, this criminal prosecution has to be stayed for a while. And in the meantime, my lord, this examination can be. This, otherwise, my lord, this is a clear-cut abuse of the process of the law. How can, on the basis of second, I cannot be prosecuted twice for the, my lord, same offense, my lord. How can I be prosecuted? Where is the law, my lord? Law doesn't permit that. That is, it is legally impermissible, my lord. So that, my lord,
Your Lordship, if-
and no, there is no any prejudice would be caused, my lord. It's only 3110, my lord, that GR case may kindly be, my lord, stayed for a while.
if I may.
That is very important. Oh, my lord, if wants to me to read out the judgment, my lord, it's a very clear-cut law, my lord. May I read, my lord, judgment?
No, I've gone through the judgment.
TT Anthony case, Arnab Goswami case, my lord, all these things, second FIR will be mostly 161 state. This will be counted as a 161 statement. On that basis of nothing can be done, my lord. And it will be the, my lord, abuse of the process, because, my lord, everything has to be, my lord, even a punishment has to be given, it has to be done as per the procedure established by the law, my lord.
After on returnable date.
Yes, Your
My
Lordship.
Stay
Lordship,
on returnable date.
yes, Your Lordship. Even I was.
Actually, now I cannot say first FIR, second FIR,
Yes.
because the other case, charge sheet has not been laid as yet. So at
Absolutely.
this early stage.
My lord, it's so apparent on the record, my
Absolutely.
lord.
Too early to decide
Yes.
which FIR to quash, the first or the second.
Even
no,
otherwise, I was trying to rely on Apex Bank's Chirag and Pathak, Your Lordship, where it is clear that if in both the FIR charge sheets are not being filed, Your Lordship. The High Court normally under 482 should not interfere.
Then,
The
my lord,
statement.
my lord,
something made,
when
Your Lordship,
it is a matter.
Because
I will discuss both the cases and then I will not stay, or just I will pass an order for returnable date so that we will take up your matter on that day.
My
On
lord,
that
I
date. Meanwhile, the other FIR will, meanwhile, that other investigation will be complete.
my lord, we don't know when that will be complete. Question, my lord, before the issue is here, apparent there is a FIR. On the record, I have brought that.
No, I will.
Whether the question is that, my
I will
lord,
not then stay, I will reject stay then. If you insist, then I will take this, both the judgments together and I will balance it and then I will reject it. I am not, otherwise I will leave it open for the stay order to be passed on returnable date.
then my lord, in the meantime, I should face the prosecution on the basis of the second FIR.
yes, Your Lordship,
This
he
is
can,
it,
he
but
can,
I think,
he
my
can
lord,
subsequently even
my lord,
challenge it.
then we are saying that law permits second FIR, then you,
I'm not, I'm only for one day I'm asking, so that the seal, the opposite party comes to the court and then
Yes.
we get the records.
so that's why, my lord, now what is at the stage, it's only for my appearance. What is the harm will be there? Where is the balance of convenience, my lord? I should suffer for the thing,
No point.
which is not,
Let me pass an order then,
Yes.
speaking order. What do you want?
my lord,
Let me leave it open, it's for your benefit. I'm
Immediately
saying.
after
no,
vacation.
no,
Your
my
Lordship.
lord, my,
I want to leave it open so that the opposite party also comes and we'll hear both the
I
sides.
understand, my lord, that will be
Only
the,
one date, I'm asking for only one date.
but the next date, my lord, is the 31st October, the next date is fixed, that is the problem, I am not on that one. Otherwise, my lord, because it's in the case,
I have heard that it is a practice in Arunachal, once the case is filed here, then no order is passed in the lower court, usually this happens. That's
No.
what I have heard.
no, my lord, problem is that I have been summoned and case will proceed. So, my lord, will be there, my lord, next date, my lord.
Can it only be a ground for stay, Your Lordship? Your Lordship is well aware
I
that
want to
if-
leave the matter open, I don't
Yes.
want to pass a speaking order. This is for your benefit, I'm suggesting.
No, my lord, I understand, my lord, that one, that's my
Then
lord,
I'll pass an order. See, if you insist, then I'll pass an order, speaking order.
but my
I
lord,
take both the judgments into account.
my lord,
Your Lordship immediately on 6th.
Returnable date.
Yes.
Returnable date.
I, let's say, but in the
Matter of
meantime,
stay will be considered on returnable dates.
I will have to face the prosecution on the basis of the second FIR, my lord.
I know, you don't have to face, you can just leave an application and you'll be granted time.
That was,
I know how cases are dallied in lower courts.
but there is apparent illegality, my lord. Apparent illegality is there, my lord.
Your Lord is keeping the, Your Lordship,
Definitely.
yes, keeping that ground open, Your Lordship, on the next day, immediately after vacation.
Definitely. I'm not saying that the second FIR is a valid FIR.
But if we are allowing the prosecution to move ahead with that second FIR, ultimately we are approving that part only, my lord.
He'll have to prove satisfy Your Lordship. in that.
Otherwise, we are approving only that part.
Because staying,
When there is no doubt at all. My lord has seen
Only
two
one
FIR.
hearing I want to take, only
Yes.
one hearing.
My lord,
Heard Mr.
R. Sonar,
Huh?
R. Sonar, my lord.
R. Sonar, learned counsel for the item number 6.
My lord, my lord.
Learned counsel for the petitioner. The petitioner has filed an application under section 482 CRPC with prayer for. We are seeking quashing the subsequent FIR.
My lord.
Log in connection with in connection with a case arising out of the same cause of action. Heard Ms. T. Gini, learned PP for respondent number 1. The respondent number 1, T. Gini additional PP for Arunachal Pradesh for respondent number 1. Stop. The learned additional PP has accepted notice on behalf of the respondent number 1. Comma so no formal notice is required to be issued to the respondent number 1. Sufficient copies to be furnished to respondent number 1. Issue notice to respondent number 2 to register post with AD. Returnable within 4 weeks. The matter of stay will be considered on the returnable date. Matter of stay of further proceedings.
This is after vacation immediately.
Is list the matter after vacation.
My lord.
meanwhile, Your Lordship, if I may, Your Lordship, in that case, I may be, a direction may be given to me to have an this instruction with regard to the another event, the charge sheet, if the charge sheet is failed.
NDPS may obtain instructions relating to the earlier FIR
Yes.
lost in connection with the case number so and so, so and so.
And LCR may be called for your lordship.
Scan copies.
Scan
Oh,
copy
yes,
of
yes.
the
Call for the scan copies of DLC.
deeply applied.
Item number 8.
But what police has done in this case is it is reasonable, he may be
He was
asked-
caught with opium.
Yes, your lordship.
Yes, opium
10
addict.
grams, intermediate quantity of, in fact, he's,
How long has been behind bars?
Opium.
In jail?
he was
it is
arrested
today-
on 9,
Today it is
3rd of
38
September.
38 days.
38 days.
My
Let him
case,
remain for till 60 days.
Yes.
my case is.
because there was another person who had, in fact, his house was raided for the purpose of and they have discovered the opium, your lordship. And as per his own statement, there is another person who has sold those opium to him for a worth of 27,000, your lordship. Now he's not cooperating with the fact that he's not disclosing the name of the person who has sold him those opium for
Come after 60 days.
My case is, my case is that I have been, this section 21B has been inserted against me. Because
27.
in my case, this is a raided case under section 50 of NDPS
27 is
27.
addiction.
your lord,
27 consuming.
21B, your lordship.
21B,
No, he's booked on
that is
27 also.
intermediate quantity.
No, 27 is not there, your lordship.
Intermediate quantity.
But in the petition.
Section-
it is
27, yes, yes, your
Inter-
lordship, 21B,
Allegation is
27.
21B. But it is not the case of 21B. It is simply a drug addict case. The police has this reported before the police station Ponsa saying that there is some suspicious activities going on. So they have decided to search the location. Accordingly, they come to my house and arrested me on the day itself. And they made a search operation. They are saying that they have received some 10.71 grams of heroin, suspected heroin. Whereas it is not the case. Kindly see.
So
This
he's
is
an addict.
completely.
No, your lordship will
Huh?
see his own statement at page number
I-
35 of the CD, your lordship.
That is,
The Kani, they have not even included the Kani during the this operation, your lordship. He has himself stated this,
Ma'am.
that 10 gram, he had a
ma'am,
person, just let me finish. A person had called him up to sell it, your lordship, and he had bought it for 27,000, your lordship, for selling, your lordship.
Page number?
35, your lordship, of the, your lordship will find in CD, your lordship. 34 is the statement of the complainant, your lordship.
One so.
Yes,
So-
your lordship.
This is not opium, this is
I'm-
heroin.
yes, that is why I'm submitting.
The Kani, he is
I'm-
addicted to
May-
Kani, your lordship. He has
May-
admitted to the fact, but then
May-
the seized items were suspected heroin.
May I submit my part, Lordship? The case here in this wrong case has been inserted against the accused person because section 21B. Admittedly, he is a Kani addicted, that opium addicted. Kindly see seizure memo. Seizure memo is page number 13. This seizure memo is of 1st September 2023. 1st September 2023. This FIR is
Heroin
On-
weighing 10.70 grams and other two
Yes.
incriminating items
that's
using consumption of opium, 2 local bamboo pipes.
Yes.
yes, that is.
So he will
Kind-
not smoke with 2 pipes, he will smoke with 1 pipe only. If he is-
Kindly see my part.
The next,
Why wrong case has been made out again? Kindly see the report, Lordship. Why wrong case has been made out against this accused person? Because the material, this Kani and this heroin in question has been seized on 1st September 2023. And FIR has been, when FIR has been registered, FIR has been registered on this second 9, 2nd of the September. 2nd of the September. Even before lodging of the FIR, this Kani in question has been seized by the investigating authority. This is a wrong procedure.
No, your lordship.
That cannot.
Especially in NDPS cases, your lordship will
How
see
that
the
can be?
content of the FIR itself say
Without
all
lodging
dated
FIR, the
1/9. 2023. This is after
What
the
is the right
procedure
of the
was-
police without any FIR?
that's absolutely
This is the
wrong
case.
submission. Even otherwise, your lordship,
This is, they
60
have completely against the section 50 of the
with
NDPS.
regard to any
This is the
addicted
case.
addicted person, your lordship, since 27 is also here, your lordship. 64A of the NDPS clearly
That is-
states
that is-
that it's not
that
with
is
regard to
why-
bail. If he is willing to go to the rehab
That
That is
center,
why, that is
Yes.
why I am,
Usually I grant bail to
Lordship,
addict,
that
but
is why
this
I am
is
submitting.
Yes,
a
your lordship.
different type of
Since,
addict.
since there is a abuse of the process in registering the, this case,
Hmm.
even then, the accused person is a Kani addicted person, is a opium addicted person. Let us not see this accused person as a criminal, rather it is a.
Addicts I grant bail.
Yes, That is-
Addicts, even district judges also grants bail.
yes, that is
Session
why
judges also.
Yes.
I am praying.
Only a 1 month heading in, those are
Yes.
cases for 1 month, and actually they are the victims, they are not the offenders.
That is why I am praying for Lordship, so that he may go to the rehabilitation care. He may be released because section 50 has been abused by the investigating authority. Yes, authority has made out a wrong case against this accused person. And kindly see the record, this decision of this sessions special court. So special court has said some material has been made out against the accused person. Here is a sufficient material against the accused person. That is why bail cannot be granted. That is the issue here. Whereas admittedly, this is, if that is a consumption case that can be granted, that is a bailable offer. But even if it is not the bailable case,
Intermediate quantity,
this is the case.
10.1 grams of
If
heroin.
section 21 is not inserted, this is not the, it is 10 point certain gram is there in case of heroin. Heroin. Kindly see how heroin has been seized. Heroin has been seized even before loading of the FIR. That is the case. He has been illegally detained.
Come after some days,
in fact,
After,
if your lord,
come next week,
yes.
I won't be there, but
In fact, your lordship has clearly seen his statement also, your lordship. Your lordship has read his statement
I'm-
also. The
I am
purpose,
submitting my part. Police has abused the process. It is admittedly without FIR, Lordship.
let it come on the
That
last
is the
day,
case.
we'll grant him bail.
Yes.
yes, your lordship will, however,
Hmm.
with regard to your lordship will, only my contention with regard to
I may
this
be
is,
allowed to
why-
go this rehabilitation camp since I am a married person.
yes. Your
Let-
lordship will,
No. You were trading in
I have,
opium.
any.
You were having opium and trading in heroin.
That is.
So you
I-
come on Friday, I'll grant you bail, not today.
Yes. Friday,
So
maybe
as
fix it Friday.
Learned counsel for the petitioner has prayed for adjournment with the matter. Okay, on Friday after
Yes.
4 days, all right?
Yes.
After 4 days,
Yes.
35, 38 plus 4, 42.
Yes.
Okay,
Um,
please the matter. Friday.
Friday.
Exam.
leave your place.
My lord, in this case, I've gone through the records, my lord, the LCR, the scan copy of LCR.
Of my bail by the special judge Pasigat.
Yes.
So your honor, my bail has been cancelled without any valid reason.
Hmm.
Only on the ground that my counsel has failed to appear before the special judge on 3 occasions.
On 3
Madam-
occasions, you didn't appear. Have you received the LCR?
Yes, your lordship.
Huh?
LCR is there, your lordship.
So on 3 occasions, he has not appeared. Should we direct him to appear before the session judge?
No, your
No, my lord,
lordship,
here
it's not
the
the case.
counsel for the accused, he did not appear on 3 occasions. The accused was present all the time.
Okay.
But on the 4th date, the special judge has passed the order that the accused is not cooperating
So
with the
what you have prayed to cancel what? NBW?
No, his
Yes.
his
Ca-
bail was cancelled. So he had come on the 482 to
What?
challenging that order.
Order.
Yes,
No, my lord, in this matter, my only regard to is that since 482, even the Guwahati High Court rule mandates that and since this is also a POXO case, your lordship, then the complainant has to be made a party, your lordship.
no, your order here.
It
this-
just went out of my mind. I just missed it.
Yes, my lord,
We'll
even,
have to hear her.
my lord, even I'm aware of this, but the
Not the
thing,
victim, at least her parents. Have you read them as respondent number 2?
no, your honor, here, I've not violated any of my terms and conditions of the bail. Only reason is that my counsel
No,
did
no.
not appeal.
In a POSCO case,
So, and-
whatever it is, we'll have to hear in any type of matters, POSCO case. the
Yes, and
notice
lordship,
has been circulated.
And the cancellation of my bail also has been done illegally because there was no application filed by the prosecution for cancellation